So what happens when your partner passes away but leaves no will behind? Wait a moment. Let's say you've been in a relationship for nearly a decade and even have children together. What then? What happens to the estate?
In recent weeks, we've seen Bianca Naidoo, the life partner of the late recording artist and businessman Riky Rick, battling to be recognized as his wife and executrix. But what ground does she have, given the dynamics of their relationship? Well, legal expert Nthabiseng Dubazana joins us now to discuss this further. Nthabiseng, a very good morning to you, and thank you very much for joining us on the South African Morning. I'm sure you've heard all of those questions, so we're gonna really just look at those questions before we get into the meat of everything. What happens in Bianca's case? You've been together for a decade. You've got children together. She's contributed to that estate, both emotionally and definitely financially. She's invested her entire existence in that estate. And now the law says, yeah, but you're not his wife. What does she do?
Well, not much, actually, because unfortunately, in terms of the law, cohabitation is not a marriage. So even if you've been together for 20 years, doesn't matter how long you've been together, you are not married. So you cannot benefit in the manner in which a spouse can benefit within a marriage. So I've always heard that this term that because we've been together for this long, I am a common law marriage to this, common law wife, I beg your pardon, to this person. There's no such thing. Can we please just, let's just put that on the back burner. It doesn't exist. Cohabitation in terms of our law is viewed as a business, not even as a relationship. So basically there's 4 things that need to be adhered to in order for that cohabitation to be recognized in some form or another as a contract between these 2 people. So it's called an entity. So the parties both equally have to be pouring into the entity financially. It should be equally for their benefit into the entity, and any properties or anything bought by the parties should be for the benefit of the parties within that entity. So it is viewed as an entity. An entity is a business at the end of the day. So that is how it is viewed, and it is viewed if what we call a universal contract is drafted between the 2 parties, and that's about as far as it goes in terms of what you can benefit from this relationship. So that is just the cohabitation side alone. So now we're dealing with the side of when now you have had children within the marriage. Before a recent case law, just forget the citation, but before the recent case law, it did not matter that you have children with this person. You will still not be recognized as a wife or as a spouse. You would still not inherit from the estate, the deceased estate of your partner. But now only your children rather would inherit because they're direct and blood heirs for the estate. But now with this new case law, it says that in terms of the umbrella, or in terms of spouse, and only under intestate succession can that also be clear. It can't be under intestate, which is where a will is left. So under intestate succession, this is when you will now be viewed as a spouse. And also, if you meet this certain criteria that I spoke of earlier, it's not an automatic thing that you'll be viewed as a wife for the purpose of inheritance under intestate succession. There's a criteria, a checklist that needs to be met to show that indeed you were in a partnership, and not that you're coming out all of a sudden now that this person is late and now you want to inherit.
You have just literally blown our minds, because I think Morena and I are sitting here going, but hold on a second, Nthabiseng. Was it not a conversation within the legal fraternity about a year ago or so that if you live with a partner for 6 months and more, and you are shown to be contributing equally to their estate, you are shown to be purchasing groceries, helping to pay the bond payments and the like, that automatically it entitles you to half? I think it was this whole notion around, exactly what that, cohabitation. So does that mean that it was still under review and discussion? It has not as yet been enacted, and therefore the law does not apply to it. Where are we now with this? Because I remember a huge conversation around 6 months or more. If I can show that I've been contributing to the estate, automatically it means that I'm entitled to your estate, right? And then now versus what you're saying, I mean, does that mean it was a proposal, not necessarily enacted?
100%. It was a proposal, and people are fighting it. because people are saying that it cannot be that I go through this entire process of marriage and then have these legal rights and everything within a marriage, and then somebody can choose to just decide to cohabitate and then have the same benefits as a wife. That is where the contention is. So it is not even a bill as yet. It is just something that is being discussed. It hasn't been put down as a bill for people to now comment on, nothing. So right now, as we speak, cohabitation does not have any legal premise, even though it is so popular amongst a lot of people, and especially younger people, who are choosing not to get married and thinking that they will have some kind of benefit from that. If we are in a relationship, and we are not married in any manner or form, if I buy a house, even though you may not have contributed to the bond or whatever, but I'm buying a house and we are both living together, I can choose to do with that house as I wish. I don't have to consult you in any manner or form. I can even sell this house to somebody else while we're still in a relationship, and you have no say over that. So I would never, for now, advise anybody to cohabit and assume that they'll be able to even get maintenance should the relationship end. But now the Maintenance Act is slowly going towards that direction, where if you can prove that you were receiving some kind of maintenance from this person, even though you were employed, if it's a significant chunk, then the maintenance court sometimes, I've seen one case so far that they're saying that, okay, maybe we can consider it, but especially because the lady was unemployed for the duration of that relationship and she relied heavily on her partner. But otherwise, there's no guarantee, there's no space within the Maintenance Act that says you can get maintenance as a result of having cohabitated, because there's no spousal maintenance for somebody who's cohabiting.
Sure.
We've seen this kind of conversation in Nthabiseng with another late rapper, that being WHP, but that particular matter involved customary law. Where does this extend in terms of customary law? You know, if I've married you, kasetu, where as my setu wife do you then have a claim to my estate? Because araya go court, we didn't go sign go court and say that by civil law we are together. Customary law, does it? Do you at least have a claim to my estate if then Faith and myself are married by customary law?
100%. And that's another thing that also has become watered down. When Huntwe Mahadi, whether or not Mahadi is paid in full, whether if the Mahadi was 10 grand and somebody paid 2,000 rand or even 100 rand, you are married. That's the bottom line. You are married, and not only are you married, you're married in community of property. So I have all the rights as a spouse to inherit from your estate. Upon divorce, I can get 50% of your estate. But here's the thing, it is I don't know why, but it is viewed as if we are engaged. And it's not the case. And then people want to come and do the anti-nuptial contract after lobola has been paid. It doesn't work that way. You're already married. So this anti-nuptial contract is null and void. So before you have discussions, Tamahadi, and all of those things, do your ANC in the manner that you want it to be, and then get married so that, you know, life can go on as usual. And then you can change the marriage regime if you want to go from customary to civil, and then you can change it to out of community of property with accrual and all of those things. But at least I can inherit from the deceased estate upon your death as your wife under customary marriage.
I want us to labor a little bit on customary marriage as well. How then do I prove that indeed we were married under customary law? So let's say on that particular day, you have a conversation, you know, the families meet, so as to say, but nothing maybe gets documented. What must be documented in order for it to actually stand in a court of law to say, actually, you know what, we are married now under customary marriage? Because sometimes I think we miss it. We go through the festivities of marriage, we go through the celebration, but we don't go through the fine print of it, right? And the administrative aspects of it. And people have to prove in a court of law that indeed they were married customarily.
I want that celebration, that is sufficient. So what happens is that if not all families want to reduce what was agreed upon in writing, even though it's always ideal, where it says that this family and that family met and this is the agreement and blah, blah, blah. It's always ideal. But without that piece of paper that confirms all of these things, if now you are now late and now I want to inherit from your estate, I now can prove, I first have to prove that I am your customary wife. So things like affidavits from people that were present on the day, confirming that they were there, in terms of mahadi. Things like the pictures that showed that there was a celebration, now we are married and all of that. Those things are taken by a court to prove that there was a customary marriage existed between the two parties. So I'm not saying do away with the letter, but I'm saying if it so happens that you forget to do the letter, or the parties forget to put it down on paper and sign, that those things are used in a court of law to prove that indeed there was a customary marriage. And especially because most people don't go and register their customary marriages after the celebrations and everything. That is the thing that we use to prove this thing. So even in a divorce, that's the first thing that we need the court to confirm. The court has to confirm that, yes, there was a customary marriage based on this, that, and that has been put before me. And now that we've established there's a marriage, let's deal with the divorce and how we are divorcing. Is there a settlement agreement? How is the estate going to be divided? All of those things. So yeah, there's many ways to kill a cat.
Sure.
All right, we're going to bounce back, Nthabiseng, between all of these points, because every time we go, off screen, Faith and I, we keep looking at each other like, Batum.
I know.
Really?
This is law shock. You've given us all a law shock.
So we're going to be bouncing back, and I can imagine the South African morning viewers themselves are just like, Batum. I want to go back to our first question, about Bianca and you saying that there's pretty much nothing she can do. I'd like you, if you can, to just essentially tell the viewers, what do you mean there's nothing she can do? So she's fighting a pointless battle. She's going to court to fight something that she will never win. Is that what you're saying?
I don't know about never, because, there must be some kind of hope or grounds that the attorneys are using for her to be viewed as a wife. What I would have probably fought for was for me to inherit in terms of intestate succession due to this recent case law that I'm saying. But now she's fighting the master of the High Court for her to be given what is this right to be the executor of the estate as if she was a wife. So that is going to be an uphill battle. Because right now it's not like the family, Riky Rick is standing up and fighting and say you don't deserve this, you don't deserve that. That is not the situation. So the situation is that the estate is being handled by the master of the High Court, and the master is saying that he will now distribute the estate according to what the heirs are being listed or how they exist, which includes her. But now trying to fight to be recognized as a wife. I don't know if you're going to be very successful in proving that you were the wife of somebody when none of the marriage regimes are even present within your relationship. I actually thought that they had, at least at minimum, dealt with the traditional things, mahadi and all of that. But in the papers that I saw, they did not even go that route because they don't believe in that. So now what are we going to do? How are we going to fight for you to be recognized as a wife?
I want us to also go into this notion of entity or interstate succession, right? And having to prove that you are indeed an entity. In her case, she's saying that the business that they're in, right? The music business is essentially everything that happened subsequent to that, subsequent to their meeting, was done from a contribution perspective, right? She was a big part of shaping his career, shaping the business, right, of the music industry, the entertainment industry that they've both found themselves in, because when she met him, he was allegedly unemployed. Are they then able to prove from that point that from a business perspective, she helped bring this person up? Because, the creative industries, there's no necessarily a PTY limited. The creative industries, you yourself are the PTY limited. So in that case, how would she then prove that she contributed to that PTY limited, which was him?
Then we go back to what we said earlier about how cohabitation is viewed as, like you just said, as an entity. She can prove, and I saw that in her papers, she can prove that she put monies and everything within the entity for the benefit of both parties and all of those things. That can be proven. So that would then form what we call the universal partnership agreement. But it doesn't necessarily give her the right as a wife, because even under that universal partnership, it just means that whatever you would have put into the relationship, you are able to get out of it, upon you guys going separate ways or upon death, etc. But it doesn't give you the same rights as a wife at the end of the day. It's just a universal partnership agreement. So I'm wondering how the attorneys are trying to tackle this situation to try and, because I wish I had access to the entire affidavit wherein they put in their reasons why the court should recognize her as a wife. And if the court does confirm there's going to be a landmark case, because now there would be no point of us having the Marriage Act and customary marriages and all of those things. But I don't know if it will necessarily be successful. I'm not really sure it will be successful.
Nthabiseng, attention span of South Africans is very short because there's always something happening in this country. There's always something that requires us to, focus on. There's always a lot of shock that we are being exposed to every day. This story at some point, just like HP's story, is just going to become one of those back page sitting there online and nobody's going to consider it anymore. But it is a story that is important in terms of you need a will. You need a will. Having a will is important because we have seen, especially Batho Babatsho, you've got families, different kinds of people coming out of the shadows to come and claim the estate of Ntate. So Ntate will have, and this is said with great respect, Ntate will have Ngwana with 3 or 4 different partners, and then Kaofela will be coming and claiming what is theirs, rightfully so, because there is no will that says you're going to get this, you're going to get that, and you're going to get that. I'd like us to labor on the point of having a will. This is something I think Riky Rick's passing is teaching us. Bianca Naidoo's fight to be the executrix is teaching us. Please speak to us about the importance of having a will, even though to my name is a couch, a bed, and a PlayStation.
I don't even know how to emphasize how much will is. It is very, very important. And then our people think and all of that, from all the way from a teaspoon that your great grandmother left you because it got sentimental value, all the way to the millions that you will have in your estate. Those are things that you put in a will because you want it to go to a specific person and you want it to be handled in a specific way. Go see an attorney and just put everything down in a will. Even a will talks to how you would want to be buried, because not all of us want to be buried symmetry and all of those things. Some want to be cremated and all of that. We put that in the will. If you've got minor children, make sure that you have appointed a guardian to take care of those children, somebody who you can trust and who will take care of those kids. So that when you do leave money, because children in quotes can't inherit through a will because they are minors, they're below 18. So there's going to be a guardian appointed for them, and that money at the end of the day. And by the time these kids become old, there's nothing left. So you're able to appoint somebody will not abuse that power that they have over your children until they've reached an age of maturity. So please, and it's September, Wills Week is coming. Most law firms have a week where they will draft wills for you for free. Please take advantage of that and go and draft a will and make sure that you protect your estate, which is you and everything that you have.
Sure. You are really opening our eyes to the importance of wills. I wonder, and Morena, I think that you will touch on children in just a moment, but let me ask you this, and I find that a lot of people in this country don't have children as yet, right? So their understanding is that I don't have kids as yet, yes. I'm not married yet, I don't have a family yet. What is the point? Because it's just me and my cousins and my nephews and my nieces and my siblings, so as it were. In that instance, right? Is a person still supposed, and who do they leave the assets to? Because maybe they want to leave the assets to the children that they don't have yet, or to a family that they don't have yet. Who do they leave assets to at the end of the day? And if they should pass before even having those children and before having those family, where does the money actually go? Or the assets, do they get frozen and then government keeps them? What happens?
So if you don't have a will and you die intestate, then you're like a child. You don't have like, your own children. So it goes ka hierarchy. If your parents are still alive, then they inherit. If they're not, your siblings inherit. If they're not, then it goes like that. You see, it goes to extended family all the way that way. And if nobody ever comes to claim anything from your estate, yeah, dula. In the estate, there's so much money that is sitting in the master's deceased estate. There's so much money, and people have not come to claim it. So if you're not married and you don't have kids and whatnot, some of us, our friends are more family than our family, and all of that. Our cousins are closer than our siblings. So just draft a will to leave things to the people that matter to you at that time. And if at some stage your family does develop and you don't die before you have a family, then you just go and you update your will. Every time, I always say update your will every 2 years, because you are not in the same place you were 2 years ago, financially or otherwise. You probably would have gained more or you would have lost. So you need to amend your will and say, okay, things have changed. Let's revoke that other will. This is now the will that we're going to focus on in the event that I die tomorrow.
Nthabiseng, I have 2 children, and
Yes.
I'm not saying that I don't have anybody that I trust, but if it were the case that I don't exactly have anybody that I trust enough to say that hankasia, whatever monies I do have, whatever I do have in my possession, and even if I didn't have anything, I wanted somebody to look after my 2 children. Why then can I not, in my will, say that, right, wena thapelo le mathapelo, here is what is going to be left to you. You are going to get it, and there will be nobody that's going to control it for you. My children are 7 and 4. So how can I not leave what is mine directly to them? Why must somebody look over for it?
Yeah.
Because they're kids. They're under the age of 18. They're not deemed to have the mental capacity to be able to handle such things. That's why the court will always appoint a guardian if you don't do it. So I always advise that find somebody that you can do that for. Otherwise, open a trust. And the people who are, and then they can benefit via the trust. And people who are trustees in there also should be people that are reliable, because they can siphon money out of the trust account as well. So it is very, it's unnecessarily complicated. People choose to just do things that are necessary. I don't know why people have I can say so that's why I always say that and you have conversations with these people while you're still alive. You know what, Faith, you're the one who when everything goes south, you are always there. In the event that I die tomorrow, I have nominated you in my will as the guardian to my children. Please do the most. So at Gausani, when the will does come out and people in the family don't even know who Faith is, by the way. And then you can come up and say, yes, we even have text messages or calls or whatever. I know these kids, they love me, blah, 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 and all of that. And you know about it. It shouldn't be a surprise, because now you're appointing somebody and they're surprised and they haven't mentally prepared that, okay, now that she's gone, I know we've had this conversation. I'm automatically going to be a mother. I'm automatically going to be a father. But then how nominate them also, and they don't know what are they going to do, because now they are being shocked and they might be bitter. Now, why are you doing this to me? And then now start treating your kids badly as well. So these are conversations Batubarona don't want to have, because it's like it's taboo for whatever reason, and it's not. We have to protect our assets.
Yeah, as you're speaking about protecting our assets as well, I'm just looking at in terms of even the benefiting of the children automatically. So there's an automatic assumption that in let's say with this case, right, Riky Rick as well as Bianca Naidoo, does that mean automatically now the children will then inherit? And how do they then inherit? Because there's no will, right? Also automatically the kids get something, but what determines how much they get or how much of their estate they get? Does it automatically all go to them as the dependents? How would it work in the situation?
Well, under interstate succession, it would be, let's make an example that they always use, that if the estate is 3.5 million, then you don't pay estate duties, so that's always good. Then the children earn 125,000. but it's an example, after everything has been paid, the debts, remember, there's also debts that we need to look at that the deceased had. So creditors now have to, get paid and all of that. So whatever remains, usually what they equate it as is, of the remainder of the estate, 125,000 would then go to the children, and then the spouse always gets a higher amount. I think, is it 250? Somewhere there, I forgot the exact amount. This is when it is used as an example. But in this situation, if she were to be seen as in terms of this new case law, if she's seen as a spouse, which the case law has confirmed, then she will earn that amount of money. Bianca would earn that amount of money put aside for the spouse, and then the children earn the 125,000, or what is called a children's share. So they don't exactly take the entire estate. So they still inherit, and then their mom is now a guardian automatically because she's still alive, and then their share is now also given to her so that she can do for the children what is necessary for them to be done to go to school and all of those things. But if Bianca was out of the picture and she was also late, then the monies would be divided between the children, and not even the moms, the uncles, and the dads of Riky Rick. It will go to the kids. But then because they are 7 and 4, for example, then there has to be a guardian who's going to oversee the usage of this money, because they can't go to banks and pay for themselves and pay their own school fees. Some adult has to do that, and that 3.5 million usually goes, and then the kids are left destitute. So sad.
Right. Just before we let you go, Nthabiseng, I'd like to complicate the situation a little bit. I have 2 mothers of my children, and I'm not together with either one of them. I'm also not together with Faith. Faith is my best friend. Now, I don't trust the mothers of my children to execute my estate the way I would like it to. I also don't have my mom or my sisters or any of my family left over. I hand it over to Faith, and I ask her to be the executor of my estate. Can the mothers of my children, because they bore my children, challenge Faith?
They can, especially the first one, because all 3 of them can't both of them can't be seen as your wife, because polygamy has its own laws as well. So the first baby mama, or the mother of your children, I'm so sorry for that term, the first mother of your children probably would have not a leg to stand on, but should probably have a stronger argument to argue to be the executor of your estate. But then the criteria, remember the cohabitation criteria we started with in the beginning, it would be like, but it's not met, that universal agreement thing is not met. So how then should you be viewed as a spouse in terms of this case that we've been referring to? So she might not really be successful in that regard. And then eventually Faith will still be continue to be appointed as the executor of the estate. So yeah, you can still do that, but then if they choose to challenge, that's what we're looking at. But the likelihood of success is slim to none.
So basically, out of this lesson that we're getting here is, number one, make sure that a contract is signed. Cohabitation does not mean that you automatically get 50% of assets at all. Rather have and more than anything else, I think this is what a lot of South Africans miss out on, Nthabiseng, is that automatically there's an assumption that after the customary marriage, right, that there's almost some kind of agreement that I have to go and then make a contract, drop the contract after the customary marriage. But after the customary marriage, already in community of property kicks in, which means that now you have to literally find amendments to the existing contract, which is in community of property. So sign a prenup, or like sign contracts way before you even or think about getting married.
Yeah.
Definitely. You've just got everything down to the T. Do everything right. Consult before you start getting yourself in any sort of contract of marriage. And then you can be able to go onto this journey knowing that you understand what you're going through. And just because Ubatlaling out of community doesn't mean you don't love each other, doesn't mean she's a gold digger, doesn't mean anything. It's just a matter of us protecting ourselves going forward. It has nothing to do with love. It's a matter of making sure that whatever road that we're going on now, whenever it ends in whatever form, death or divorce, at least assets are protected for any child or any person that we bring into this journey of marriage.
Nthabiseng, you've opened our eyes, and I think the eyes of South Africans at large where this is concerned. I mean, I know we were just speaking about Riky Rick and Bianca Naidoo, but I think it's lessons that South Africans, some of them did not know, and therefore now they do know. And thank you so much. We really do appreciate your time here on the South African Morning this morning, just sharing all of that knowledge, all of that wisdom. And I want to say, guys, go do your wills. National Wills Week is from the 12th to the 16th of September 2022. I say it again. National Wills Week is from the 12th to the 16th of September, and there are, of course, firms out there, the likes of Bona and Nthabiseng, who will be drafting wills for you for free. 12 to 16 September. We're going to be coming back to this a little closer to the time. I say it again, 12 to 16 September, go draw up your will. Even if all you have, get teaspoon that you got from your great-grandmother, put that in your will. It is very important. So, of course, that was Nthabiseng Dubazana from Dubazana Attorneys, just sharing knowledge that we did not know.
Yeah, you know, and it's so funny because there's an assumption. And remember when it all received the media kind of hype, right? This proposal about cohabitation. And so there was this general assumption that because there was a media hype about it, it automatically translated into it being enacted into law. But it's not. It was just on a stage of proposal, which means that even if you cohabitate, and I always look at, you know, South Africa sometimes deals with the issue of, and you'll always see this, is that sometimes they say that younger men and then older women who've got assets maybe, and then they'll want to cohabitate, and then how there'll be assets that have been dispersed. No, it doesn't work. So I think more than anything else, arm yourself with knowledge, because you don't want to find yourself at the losing end, especially when it comes to children, right? The kids must not think about where's daddy's or mommy's assets going to go to. You figure it out.
Most definitely. Let's make sure that we get ourselves some